I will be arguing for the defendant Rashid that his conviction be overturned based on the fact that he did not receive his Article 6 right to a fair trial, and that the judge was wrong in denying him the use of special measures for the entirety of the trial, not only when submitting evidence. Due to the vulnerabilities of the defendant and his lower IQ, this should have been granted in the form of an intermediary to help him follow and participate in his trial. The Court of Appeal maintained, with regards to the defendant's educational background and with the judge's own observations, that following Part 18 of the Criminal Practice Directions, there was no significant impairment on intelligence which would result in him being unable to follow the trial sufficiently. It ruled competent legal representation and guidance from the judge is sufficient to ensure a fair trial. Furthermore, the experts agreed that the defendant did not have a learning disability within the terms of the mental health legislation, so did not qualify for special measures. For these reasons, an intermediary was only granted while the defendant was giving evidence, not while the prosecution delivered theirs. The prosecution's argument followed that of a similar one ruled in the case of Cox, which downplayed the need of an intermediary, stating the fairness of a trial does not rest upon their provision, and the trial judge is sufficient in giving guidance to ensure that a fair trial is maintained. However, I believe that the issues highlighted in this case are on a much wider scale. The all too frequent tendency of the courts to deny the use of an intermediary and the high threshold in obtaining one is a blatant deprivation of Article 6 of the Human Rights Act, a right to a fair hearing. This very much applies to, but is not restricted to, the case of the defendant. An implied right under Article 6 is the right to effectively participate in your trial. What effective participation is was set out by the European Court of Human Rights in SC versus the United Kingdom, where they said the accused has to have a broad understanding of what the nature of the trial process and what is at stake. They should be able to understand the general thrust of what is said in court, and they should be able to follow what is said by the prosecution witness and be able to communicate effectively with his own lawyers. The Human Rights Act binds UK courts to uphold all the convention rights, including this one. So surely any means to do this should be readily available to the defendant, and there is no justifiable reason why the courts are so strict in their provision of intermediaries to defendants. It was ruled in R versus Great Yarmouth Youth Court in 2011, an intermediary should always be there as a precaution, even if there is just a small risk that the trial could be unfair. Despite the experts ruling in this case in question today that the defendant did not have a learning disability under the meaning in the Mental Health Act, there is a clear risk that he is a person of extremely low intelligence and that his position was comparable to that of a person who did not even speak English. It is clear that assistance from an intermediary was needed throughout the entirety of the trial in order for him to obtain his convention right to a fair trial and effective participation. Again, referring back to the problem of it being on a larger scale, 7% of adult prisoners have an IQ of less than 70, and a further 25% have an IQ between 70 and 79. It is clear that many defendants most probably struggle to understand their court proceedings. As it is extremely rare for a defendant to obtain an intermediary during the court process, it is likely as a result that they did not get a fair trial and they were not granted their human rights. The defendant was also deprived of yet another implied right under Article 6.1, the equality of arms between the prosecution and the accused. As a result of the Youth Justice and Criminal Evidence Act, intermediaries are readily available for vulnerable witnesses for the prosecution, but the use of intermediaries for the vulnerable defendants is explicitly excluded from this provision, disadvantaging Rashid. Despite this more recently being extended to include defendants in Section 104 of the Coroner's Justice Act, the provision has not been implemented. The failure to implement this provision is obviously highlighted in this case, effectively ignoring the parity principle and giving the prosecution an unfair advantage. Furthermore, it is unfair that even if the defendant was granted the use of an intermediary for the entirety of the trial, it would be an unregistered one. The prosecution, however, would have access to a registered intermediary, which is funded by the Ministry of Justice Witness Intermediary Scheme. It is supposed that they are of a higher quality in comparison to those that are accessible by vulnerable defendants, a system which the Prison Reform Trust labelled as anomalous. Similarly, Lord Justice Rafferty said an intelligent observer would be confused as to why the accused is not allowed the same calibre of support as everybody else, and that the Ministry of Justice should reconsider. The difference in what is accessible to defendants is perplexing and a clear inequality of arms. Despite these opinions, nothing came from it. There was an attempt by the courts in R.V. Camberwell Green Youth Court to reduce the inequality of arms that arises as a result of these provisions, or lack of it. It was suggested that the use of special measures should be denied to vulnerable witnesses as well as defendants in order to maintain the parity principle. Upon appeal, Lady Hale said to deprive the court of the best evidence just because the scheme doesn't apply to defendants also would be the worst of all worlds. In turn, this implies that the provision of special measures should be extended to include vulnerable defendants also, in order for the court to hear the best evidence. This supports the idea that the defendant today should have had an intermediary throughout the duration of his trial in order to maintain the principle of equality of arms. The judgment by Lady Hale does not, however, rectify the difference in quality of the intermediaries. Lord Justice Thomas suggested that a cultural change would be needed in order to do so. The use of special measures by the defendant in this trial should also have been granted on the basis of fulfilling Roberts and Zuckerman's underlying principles of the criminal evidence system, more specifically to this case, the principle of accurate fact-finding. If the defendant is struggling to follow and communicate during the trial, such as Rashid was, the likelihood of maintaining accurate evidence decreases. Surely the use of an intermediary would have helped in maintaining this principle. Similar to this is Rule 3 of the Criminal Procedure Rules, which states that the court must take every reasonable step to facilitate the participation of any person, including the defendant, enabling them to give their best evidence. In order for the accurate facts and best evidence to be uncovered, the defendant must fully comprehend the proceedings and engage with their defence. Arguably, interfering with the pursuit of best and most accurate evidence is the inherited powers of the court at common law. In R versus SH, it was ruled that judges possess the power under common law to provide an intermediary, despite it not being in statute. This decision was down to the judge's discretion alone. Controversially, it is not clear that judges are better placed than doctors in determining the defendant's ability to play a meaningful role in their trial. In this case of Rashid, the judge chose to ignore the evidence given by numerous psychologists that the defendant is intellectually impaired. In particular, Dr. Hathaway concluded his IQ was that of 55 and would indicate significant learning disabilities. She added that the defendant presented as much more able than he actually is. Despite this, it was the trial judge's opinion that special measures would not be necessary for his participation in the trial. There is almost a worrying trend that judges show a willingness to ignore medical evidence, such as in this case, that of CPS versus P, and in that of R versus McGill, Hewitt and Hewitt. This expands to pre-trial processes also. McLeod pointed out that police find it difficult to identify support needs due to lack of training. This is represented in the case as there was a lack of an appropriate adult in Rashid's primary interview, and Wisgill added that the problem even expands to barristers. In summary, the defendant should have been granted special measures in the form of an intermediary during his trial. The lack of one interfered with his human rights and the principle of accurate fact-finding, which should be ensured in the interest of public policy. There does not seem to be, in my opinion, any justifiable reason why the court would not provide an intermediary, even if there was a slight risk that the defendant was unable to effectively participate. It would not inhibit the trial in any way and could only have positive effects in terms of finding justice for both the victim and the accused. Due to the scope of the trial judge's inherited powers, the lack of provision of special measures to vulnerable defendant on a wider scale seems to be down to them, and interference from the European Court of Human Rights is needed to provide clarity on the issue. A potential reason for the court's reluctance to give vulnerable defendants special measures in the form of an intermediary may be down to lack of funding, as pointed out by Fairclough. However, this seems to be an inadequate explanation for the deprivation of all defendants' human rights.